There is a moment when something illegal happens to someone personally, and it's so blatant, so obviously wrong that it almost feels unreal. Standing in a manager's office, 7 weeks pregnant, listening to him explain that the work schedule was being adjusted and the hours were being cut from 40 per week to 25, effective immediately. The reason? Business needs require more scheduling flexibility. But here's the thing. Announcing the pregnancy happened on a Monday. The schedule reduction was announced on Wednesday, 2 days. And suddenly, after 2 years of full-time hours with zero issues, business needs required cutting nearly 40% of the income. My name is Samantha Wilson. I'm 28 years old, married, and I was a retail manager at Omega Fashion Stores in Minneapolis. This is the story of how a manager's attempt to quietly push out a pregnant employee became a $320,000 mistake that cost him his job. Before getting into what happened, a quick note. Stories get shared here regularly about workplace discrimination, people who fought back, and justice being served. If that sounds good, the subscribe button is there. These stories drop consistently, and this one's just getting started. Starting at Omega Fashion Stores 2.5 years ago as an assistant store manager, Omega was a mid-sized retail chain, about 30 locations across the Midwest, selling women's clothing and accessories. Nothing fancy, but steady work with decent pay. The job was typical retail management, opening and closing the store, managing inventory, supervising sales associates, handling customer issues, hitting sales targets. The hours were consistent, 40 hours per week, sometimes more during busy seasons. The pay was $42,000 annually, which worked out to about $20 per hour. Christine Brooks was the regional manager, my direct supervisor. She was 53, had been with Omega for 12 years, and managed 5 stores in the Minneapolis area. Christine was old-school retail management, demanding, numbers-focused, and not particularly warm, but professional enough. The relationship with Christine was fine, not friendly, but functional. As long as sales targets were met and the store ran smoothly, she left things alone. For 2 years, that's exactly what happened. Sales targets were consistently met or exceeded, the store had low turnover among sales associates, which was rare in retail, customer satisfaction scores were solid, there were no performance issues, no complaints, no problems. Then, in February, finding out about the pregnancy. My husband and I had been trying for about 6 months. When the pregnancy test came back positive, we were thrilled. Nervous, first-time parents, lots to figure out, but excited. Waiting until the end of the first trimester to tell anyone. That's standard advice. Wait until the pregnancy is more stable, then start making announcements. At 12 weeks, telling family and close friends. Then, the following Monday, telling Christine. The conversation was straightforward. Called Christine to schedule a meeting at the store during a quiet afternoon. Christine, I wanted to let you know that I'm pregnant. I'm due in early September. I'll need to take maternity leave around that time, and I wanted to give you as much advance notice as possible so we can plan coverage. Christine's smile was tight. Congratulations, Samantha. That's wonderful news. Thank you. I've looked into the FMLA requirements, and I know I'm entitled to 12 weeks of unpaid leave. I'm planning to take that time, probably starting a week or 2 before my due date. Of course, we'll figure out the logistics. How are you feeling? Good. A little tired, but nothing that affects my work. Good. Let me review our policies and get back to you about the leave process. And Samantha, make sure you're not overexerting yourself. Pregnancy can be demanding. That last comment felt patronizing, but whatever. Christine had never been pregnant as far as anyone knew, so maybe she was just trying to be considerate. Walking out of that meeting feeling relieved. The hard part was over. Christine knew there were 6 months to plan the transition and everything would work out. 2 days later, Christine called. Samantha, can you come to the regional office tomorrow morning? I need to discuss some scheduling changes with you. Sure. What time? 9 a.m. See you then. The next morning, driving to the regional office, Christine's assistant directed me to a small conference room. Christine was already there, along with Jonathan Wright from corporate HR. HR in the room was never a good sign. "Thanks for coming in, Samantha," Christine started. "I wanted to discuss some operational changes we're implementing at your store." "Okay." "Due to shifting business needs and the need for more flexible coverage, we're adjusting your schedule. Effective next week, you'll be moving from full-time hours to part-time hours, approximately 25 hours per week." The words didn't process immediately. "I'm sorry, what?" "We need more scheduling flexibility at the store level. Rather than having you work 40 hours on a fixed schedule, we're reducing your hours and distributing coverage differently throughout the week." "Christine, I've been working 40 hours a week for 2.5 years. There's never been an issue with my schedule or flexibility. Why is this changing now?" "Business needs evolve. We're making these adjustments across several locations." "Which locations?" Christine hesitated. "We're starting with your store as a pilot program." "So just my store, just me, 3 days after I announced my pregnancy?" Jonathan from HR jumped in. "Samantha, this is a business decision based on operational needs. It has nothing to do with your pregnancy." "My schedule has been fine for 2 years. Sales are strong, the store runs smoothly, and I've never had a single complaint about availability or flexibility. Now, 48 hours after telling Christine I'm pregnant, suddenly there's an operational need to cut my hours by 40%? "The timing is coincidental," Christine said. "Is it? Because from where I'm sitting, it looks like I announced my pregnancy on Monday, and by Wednesday, you're cutting my income by $17,000 a year right when I'm about to have a baby and need that money most." "That's not what's happening here," Jonathan said. "This is about operational efficiency." "Then why didn't this operational efficiency issue come up last week or last month or last year?" Neither of them had a good answer. "What if I don't accept the schedule change?" asking. "The change isn't optional," Christine said. "It's a business decision about how we staff the store." "So I either accept a 40% pay cut or quit?" "We're not forcing you to quit. We're adjusting your role to meet business needs." Walking out of that meeting shaking with anger. The pregnancy was announced on Monday. By Wednesday, the hours and income were cut by nearly half. They weren't even trying to hide what they were doing. That afternoon, going home and telling my husband what happened, they cut my hours, effective immediately, from 40 hours to 25. Can they do that? Legally, maybe, if it's truly based on business needs, but 3 days after announcing a pregnancy, that's not business needs, that's discrimination. What do we do? Call a lawyer. Spending that evening researching employment attorneys in Minneapolis who specialized in pregnancy discrimination, found one named Maria Santos with excellent reviews and a track record of winning cases against large employers. Called her office first thing the next morning. The receptionist scheduled a consultation for 2 days later. At the consultation, laying out everything for Maria, 2 years of stable, full-time employment, consistently meeting or exceeding performance targets, 0 issues with scheduling or availability, the pregnancy announcement on Monday, and the schedule reduction announced Wednesday. Maria listened carefully, taking notes. When finished, she leaned back. "Samantha, this is textbook pregnancy discrimination. The timing alone is damning. 2 days between your pregnancy announcement and a major reduction in your hours and pay. That's not coincidence, that's retaliation." "Can they really not change my schedule?" They can change schedules for legitimate business reasons, but when they change a pregnant employee's schedule days after learning about the pregnancy, causing significant financial harm right when she needs income most, and they can't point to any genuine business justification, that's illegal under the Pregnancy Discrimination Act. What do I need to prove? We need to show that the stated reason, or operational needs, is pretextual. That means demonstrating that your schedule was fine before the pregnancy announcement, that the store's operational situation hasn't changed, and that the real reason for the change was your pregnancy. How do we do that? We'll need documentation, employment records, performance reviews, schedule history, sales data, anything that shows your store was operating successfully with your full-time schedule. We'll also request internal communications from Omega about the schedule change decision. If there are emails discussing your pregnancy in connection with the schedule change, that's smoking gun evidence. What happens next? We file a charge of discrimination with the EEOC, Equal Employment Opportunity Commission. That starts a formal investigation. We can also file a lawsuit immediately if you want to move faster, or we can wait to see what the EEOC investigation uncovers. Let's file with the EEOC. Maria filed the EEOC charge within a week. The charge outlined everything: the pregnancy announcement, the immediate schedule reduction, the timing, and the lack of any legitimate business justification. Omega responded with the standard corporate denial. Their position statement claimed the schedule change was based on evolving operational requirements and had nothing to do with Miss Wilson's pregnancy. But the EEOC investigation dug deeper. The investigator, Thomas Caldwell, requested documentation from Omega: sales records, staffing schedules, internal communications, and information about schedule changes at other locations. What he found was damning. First, Omega's sales data showed that the store's performance had actually improved in the 3 months before the schedule reduction. Sales were up 8% compared to the previous year. There was no operational crisis requiring schedule changes. Second, staffing schedules showed that full-time management had been standard across all Omega locations for years. The claim that this was a pilot program for more flexible scheduling was contradicted by the fact that no other stores had implemented similar changes. Third, and this was the smoking gun, internal emails between Christine and Jonathan from HR showed they discussed the schedule change explicitly in the context of the pregnancy. One email from Christine to Jonathan, sent the day after the pregnancy announcement: "Samantha just informed me she's pregnant and will need extended leave in September. This creates a significant coverage challenge. I'm thinking we should adjust her to part-time status now to start training additional coverage and reduce our exposure when she's out on leave." Jonathan's response: "We need to be careful here. Reducing hours immediately after pregnancy announcement could create discrimination claims. Can we document a business justification?" Christine's reply: "I'll frame it as operational efficiency and scheduling flexibility needs." They knew it was discriminatory. They discussed how to disguise it. They did it anyway. Thomas Caldwell from the EEOC called after reviewing the evidence. "Samantha, I'm issuing a finding of reasonable cause. The evidence clearly shows that Omega reduced your hours in retaliation for announcing your pregnancy, and the business justification they've provided is pretextual." What does that mean? It means the EEOC has determined that Omega likely violated federal law. We'll attempt conciliation, basically giving them a chance to settle. If they refuse, you can request a right to sue letter and take them to court. What kind of settlement should I expect? Given the evidence and the clear timing, you're looking at back pay for lost wages, potential front pay if you choose not to return to work there, and possibly damages for emotional distress. Cases like this often settle for 6 figures. The EEOC's conciliation process started 3 weeks later. Omega's attorneys initially offered $35,000 to settle, basically 6 months of the lost wages from the hour reduction. Maria Santos laughed when she heard that. "They're lowballing because they hope you'll take quick money and go away. We're countering at $400,000. That seems high. Not when you consider what they did.
They cut your hours by 40% specifically because you're pregnant, right when you need income most to prepare for a baby. They discussed how to disguise the discrimination in writing. They knowingly violated federal law. That deserves significant damages. The negotiations went back and forth for 6 weeks. Omega eventually settled for $320,000, structured as follows: $34,000 in back pay for lost wages from the hour reduction through settlement, $68,000 in front pay, 2 years of lost wages assuming the full-time position would have continued, $200,000 in compensatory damages for emotional distress and harm, $18,000 for attorney fees. Total, $320,000. The settlement also required Omega fashion stores to restore to full-time status immediately, provide mandatory pregnancy discrimination training for all managers, revise their policies on schedule changes for pregnant employees, provide a neutral reference. And Christine Brooks? The settlement specified that she could no longer supervise any pregnant employees or make decisions about their schedules without HR oversight. Signing the settlement agreement in June, about 4 months after the hour reduction, the money arrived 3 weeks later. The settlement gave financial security for maternity leave and the early months with the baby. More importantly, it was validation that what happened wasn't just unfair, it was illegal, and the company paid dearly for it. Returning to full-time hours immediately, as required by the settlement, Christine barely spoke to anyone anymore. Every interaction was stiff and formal, clearly afraid of creating more evidence for potential future claims. The other managers at Omega heard about the settlement, not the amount, but that a pregnancy discrimination claim had been filed and settled. Several of them reached out privately to say they'd experienced similar treatment but hadn't known it was illegal. One manager, Jessica Martinez, told me Christine had pressured her to work through medical complications during her pregnancy 2 years earlier. I almost lost the baby because I was afraid to take the time off Christine made me feel guilty about. I wish I'd known I could have fought back. That was the hardest part, realizing how many other women had been pushed around by managers like Christine and never knew they had rights. Working through the pregnancy was easier with full-time hours and income restored. The baby, a healthy girl, was born in early September, taking the full 12 weeks of FMLA leave as planned.
Christine didn't last much longer. About 2 months after returning from maternity leave, hearing that Christine had resigned to pursue other opportunities. Corporate speak for, "We can't keep her after she cost us $320,000 in a discrimination settlement." That was 18 months ago. Still working at Omega, now with a new regional manager who's actually supportive and professional, the store continues to perform well, the team is solid, and there's been zero drama about pregnancy or family needs. The $320,000 settlement changed things financially, paid off debt, built up savings, and created a cushion that made the transition to parenthood less stressful. It's money that should never have been necessary. A full-time schedule should never have been taken away in the first place, but it made a difference. More importantly, the case created change at Omega. The mandatory training happened, the policy revisions happened, other employees saw that pregnancy discrimination had consequences, and managers realized they couldn't quietly retaliate against pregnant workers without facing legal action. As for Christine Brooks, last heard she was working at a small boutique in a non-management role. Apparently, being known in the retail industry for costing your employer hundreds of thousands in a discrimination settlement doesn't help career advancement. Several other Omega employees reached out after the settlement, asking about employment lawyers. 2 of them filed their own claims for different discrimination issues. One settled quietly, the other is still pending. Here's what was learned from fighting pregnancy discrimination. Document everything. The timeline, pregnancy announcement Monday, hour reduction Wednesday, was crucial evidence. Without clear documentation of timing, proving discrimination would have been harder. Know your rights. Pregnancy discrimination is illegal under federal law. Companies can't reduce hours, cut pay, or retaliate against employees for being pregnant. If something feels wrong, it probably is. Get a lawyer fast. Maria Santos filed the EEOC claim within days and moved aggressively. Waiting or trying to handle it alone would have given Omega time to manufacture better justifications. And finally, companies that try to push out pregnant employees always think they're being clever. They frame it as operational needs or scheduling flexibility or business requirements. But when the timing is obvious and the justification is weak, discrimination is easy to prove. Christine thought cutting hours 2 days after a pregnancy announcement would fly under the radar. Instead, it cost Omega $320,000 and cost her the career. One more thing. Stories like this get shared here regularly. People standing up to discrimination, toxic managers facing consequences, and justice being served. If these stories are hitting the spot, subscribing would be great. More content drops consistently. Real stories, real victories, real satisfaction. The button's right there. Thanks for listening. Now go know your rights.